Please be seated. The sitting is open. For reasons duly made known to me, Judges Tomka and Yusuf are unable to sit with us today. The court meets this morning to hear the second round of oral argument of Armenia on the preliminary objections raised by the respondent in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. I shall now give the floor to Mr. Konstantinos Salonidis. Sir, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, I will begin Armenia's second round submissions by responding to Azerbaijan's arguments on Wednesday regarding the negotiation precondition. I will briefly make 3 points. Turning to the first point, the Council for Azerbaijan on Wednesday admitted that the Court has never excluded what he calls pre-negotiations from the concept of negotiations. But he argued that such exclusion should be, in his words, the logical consequence of the Court's definition of negotiations. In support of this argument, Counsel stated, I quote, "In Georgia versus Russia, the Court held that negotiations require that the subject matter of these discussions must relate to the substantive obligations under CERD." But that is not what the Court said. I invite the Court to closely review the Wednesday transcript, which is now on your screens, with the passage I just highlighted in yellow. As the transcript makes clear, only the phrase substantive obligations under CERD falls within quotation marks. The remainder is Council's own representation of the Court's views. Now on your screen is the paragraph from Georgia versus Russia that Counsel cites. It reads in relevant part, I quote, "In the present case, the Court is therefore assessing whether Georgia genuinely attempted to engage in negotiations with the Russian Federation with a view to resolving their dispute concerning the Russian Federation's compliance with its substantive obligations under CERD. So what matters is not that each and every discussion between the parties directly concerned the substantive obligations, but rather that the negotiations were conducted with a view to resolving the dispute concerning the substantive obligations under CERD. And I would be remiss if I did not point out how distant we are from the facts of Georgia versus Russia and the questions they posed about whether the CERD had even been the subject of discussions in the first place. The Court's definition of negotiations that supports Armenia's position that what opposing counsel has referred to as pre-negotiations should not be excluded from the concept of negotiations, as long as they are conducted with a view to resolving the dispute concerning the substantive obligations under the CERD. And there can be no dispute that all of the parties' exchanges that Armenia has put on the record were made with a view to resolving the dispute concerning Azerbaijan's substantive obligations under the CERD. As I mentioned on Tuesday, the Court's jurisprudence in fact supports affirmatively Armenia's position. Azerbaijan had no response to this on Wednesday. As I also mentioned on Tuesday, Azerbaijan's own pleadings in the Azerbaijan versus Armenia case did not distinguish between pre-negotiations and negotiations. Azerbaijan had no response to this either, instead pointing to alleged important differences with an application filed a mere week after Armenia's. And as I further mentioned on Tuesday, Azerbaijan's position would enable a respondent to invade the Court's jurisdiction under Article 22 by repeatedly raising procedural and technical matters and delaying agreement in that regard, after having pro forma declared its alleged willingness to negotiate. Azerbaijan once again provided no response to this point on Wednesday. Moreover, as the court emphasized in Ukraine versus Russia, the CERD requires state parties to eliminate racial discrimination without delay and emphasizes the need to do so speedily. The court, for this reason, among others, found Article 22 to impose alternative rather than cumulative preconditions. For the same reason, Article 22 should be interpreted so as not to exclude pre-negotiations when they are made with a view to resolving the dispute, especially when they are being imposed as a condition before any substantive discussion may begin, as was the case here. Otherwise, again, respondents could undermine the speedy elimination of racial discrimination. To conclude on this point, Mr. President, all of the exchanges between the parties were made with a view to resolving the dispute. As such, they all qualify as negotiations for purposes of Article 22. I now turn to my second point regarding the context of negotiations. Azerbaijan asks you to consider as relevant context that the parties had not been on speaking terms. The parties' mutual distrust, however, did not preclude their ability to engage in direct negotiations, nor would it have precluded resolving the dispute if Azerbaijan had any genuine interest in doing so. But the negotiations demonstrated ultimately that there was no reasonable probability of a negotiated settlement. And this is even more so considering the constant aggravation of the dispute by Azerbaijan throughout the course of the negotiations. Azerbaijan argues in that regard, I quote, "Urgency has no bearing on the jurisdictional requirement under CED." But it is very telling that Azerbaijan had no response to the merits of our argument on Wednesday. And since Azerbaijan agrees that the context of negotiation matters, there is no a priori reason to exclude factors such as the urgent risk of irreparable prejudice to rights enshrined in the Convention. This brings me to my third and final point, which is that the negotiations had manifestly become futile by the time Armenia filed its application. Indeed, many of the exchanges that Council for Azerbaijan labels as pre-negotiations were not, as Azerbaijan claims, limited to procedural and technical matters. As I mentioned on Tuesday, starting from its very first letter, Armenia repeatedly asserted its substantive claims, and Azerbaijan, starting from its very first letter, repeatedly rejected them. Moreover, Armenia did consider Azerbaijan's proposals for 2 weeks and explained in the 15 September 2021 meeting why they were not acceptable to it. The negotiations here were thus not unlike those in Ukraine versus Russia, where the court found the preconditions satisfied. What matters the most, as the court noted in the Qatar-ICAO appeals cases, is that there is no reasonable probability that further negotiations would lead to a settlement, and that was unquestionably the case here. On Wednesday, Council for Azerbaijan highlighted one specific alleged proposal by Azerbaijan. I quote, "Acknowledge that the use of mannequins to depict Armenian soldiers in the military trophies park inflamed tensions between the two states. But I respectfully invite the court again to review the transcript closely. There are 2 strategic ellipses in this passage. The relevant text from Azerbaijan's proposal is as follows. Acknowledge that the use of mannequins to depict Armenian soldiers in the military trophies park in Baku and ongoing operations in Armenia by certain hate groups have inflamed tensions between the 2 states." And it goes on. Here is the next sentence. "On this last point, I should note," Azerbaijan says, "that these 2 issues are not comparable. The park memorializes the servicemen who were lost in the war and commemorates the liberation of Azerbaijan's territory, after almost 3 decades of unlawful occupation and was never intended to incite anti-Armenian hatred. Professor Murphy showed you on Tuesday what the park in fact memorializes. But for my purposes, Mr. President and distinguished members of the court, this statement by Azerbaijan was decidedly not a proposal for the amicable settlement of this dispute. It was yet another assertion by Azerbaijan that it is right and Armenia is wrong. For all those reasons, Azerbaijan cannot reduce to a molehill the mountain of negotiations between the parties in this case. Armenia respectfully submits that the negotiation precondition was satisfied, such that Azerbaijan's first preliminary objection must be rejected. Mr. President, this concludes my remarks. I would kindly ask that you give the floor to Professor Karzan to continue Armenia's pleadings.
I thank Mr. Salonidis for his statement. J'appelle maintenant à la barre, Monsieur le Professeur.
I would not like to call Professor Pierre Dargent to make his presentation. Thank you, Mr. President. Members of the court, I will confine myself to making just 3 brief introductory remarks on the presentations made by my colleagues. First remark, the points of convergence. At the end of the hearings, the parties agree on the legal tests applicable to rule on the ratione materiae objection raised by Azerbaijan pertaining to Armenia's request number 245. These are claims made in the 9th part of its memorial devoted to submissions. Parties also agree that the convention applies to armed conflict. Furthermore, Azerbaijan has not contested, 1, that ethnic Armenians were a protected group under the convention, that 2, Armenia's allegations to which it objects concerns cases of direct discrimination and not indirect discrimination by effect, 3, that a difference in treatment based on a ground prohibited by the Convention continues to fall within its scope, even if other grounds not covered by the Convention also exist. And 4, that the same facts can constitute breaches of obligations contained in distinct legal instruments. And then 5, that the Convention does contain legal obligations put forward by Armenia to substantiate its claims. Second remark, although Azerbaijan maintains that at this stage Armenia's evidence should be taken as it stands on their face, its second preliminary objection asks you in reality and in every respect to weigh the evidence, to analyze it, to the point that you have to reject it as being insufficient. If it is insufficient now, it will necessarily be insufficient at the merit stage, even in support of other claims that are not the subject matter of any preliminary objection. So what Armenia is asking you to do is totally inappropriate at this stage. Armenia requests the court to examine all the evidence for what it is, so as to draw its own conclusions in order to ascertain if the claims that are the subject matter of the preliminary objection are likely to constitute discriminatory practices that violate the Convention. Third remark, as Azerbaijan has declared at the preliminary objection stage, the threshold for jurisdiction ratione materiae to be established is low. It's a low threshold. Furthermore, as Armenia has acknowledged, and I have also recalled it, the Convention applies in the case of armed conflict. So having no way out in the face of the facts put forward by Armenia, and since it was no longer in a position to contest that the obligations relied on by Armenia to support its claim did indeed fall within the Convention, Azerbaijan has attempted to create confusion and has pulled off a 3-stage sleight of hand. At first, Azerbaijan showed itself to be reasonable. It belatedly amended its ratione materiae objection. So Armenia's second claim pertaining to abuses committed against ethnic Armenians was chopped up based on two distinctions having no basis in the Convention. On the one hand, distinctions between abuses between armed forces and civilians. On the other hand, distinctions between the periods of active hostilities and other periods. The ratione materia objection is thus made up of a ratione temporis layer and a ratione personae layer. Is that any clearer? Certainly not. But you see, that is exactly Azerbaijan's aim. Furthermore, the additional requirement of specific evidence purportedly indicating misconduct capable of falling within cert, this additional requirement applies without justification only to civilians, thus subliminally giving you the impression that no evidence is supposedly necessary or exists in the case of armed forces, in the case of arbitrary detentions or enforced disappearances, while the evidence that does exist for civilians was supposedly insufficient right from the outset. Secondly, in talks about talks style that are supposedly not negotiations, Azerbaijan argues that hate speech and incitement to hate are not what they are. That President Aliyev knows better than those listening to him what he wants to say. That seems like a reasonable proposal. It is well known, isn't it, that on the battlefield, language is made up of subtle distinctions. So words such as your kind, or your sort, or your type do not mean your race, and that these words do not denote any distinction or any contemptuous classification of the poor ethnic Armenian trembling and begging for his life. That's very obvious. Therefore, no distinction was made that is likely to be based on a ground prohibited by the Convention, and the gratuitous senseless violence unleashed was timidly acknowledged as being horrific and disgraceful and racially sanitized. Or rather, I quote, "It is not racially motivated violence in the way that is being portrayed by Armenia." End of quote. This violence is not racially motivated, at least not in the way Armenia suggests. And it's true, when it comes to racial violence, it is all in the way. Racism is not racism. Evidence is not evidence. Or even if it is, it doesn't reflect the same thing as Armenia claims. And that is obvious to one and all. Or that this evidence is insufficient. Not only is all this nauseating, all this also is imperceptibly trying to obtain a negative judgment from the court, or is attempting to pre-orient the discussions of the merits regarding evidence, also concerning claims that are not part of any preliminary objection. This is very inadequate at this stage, and I think that the court knows very well what it needs to do, and therefore I will say no more. Thirdly, Azerbaijan has pulled a scarecrow out of its magician's hat. Armenia's claims are supposedly, and I quote, "an unrecognizable and unmanageable series of entirely open-ended claims covering all allegations of unlawful violence against combatants or civilians in the active hostilities phases of an armed conflict." Here we go again. And on top of that, this time there's a shoehorned argument. To agree to your Armenia's claim would open the court's doors without limits. It would denature the convention. It would allow all armed conflicts and future wars that will tear humanity apart to be brought before the court in their entirety under the guise of the convention. Mr. President, members of the court, it is totally wrong to suggest that Armenia has submitted all aspects of the armed conflict between the parties to the court. Most of the military operations during the 44-day war and other previous clashes are not the subject matter not the subject matter of Armenia's request in any way and are not described in its memorial. Armenia has never contended that military losses inflicted on it by Azerbaijan during operations and military engagements in compliance with IHL 4 under the convention merely due to the ethnic origin of its victims, of its loyal combatants. It has never been the case and it will never be Armenia's claim. There was quite a bit of talk about prisoners of war. Armenia, in this case, is not claiming that Azerbaijan held prisoners of war, and it's not complaining about that. What Armenia is complaining about is that Azerbaijan did not take prisoners of war when it should have, and that instead its armed forces shot poor ethnic Armenian combatants down like dogs outside of combat. Or that after taking them prisoner, Azerbaijan mistreated them during their detention or held them well after cessation of hostilities or made them disappear again long after the active phase of hostilities. And Armenia contends at this stage of the proceedings, given the specific nature of this bitter ethnic conflict, given the hate speech spread at all levels of power and in Azerbaijan society, and given all the specific evidence provided in its memorial and recalled by my colleagues that these claims, as Armenia suggests, were indeed likely to constitute breaches of the convention, irrespective of whether these facts might also be unlawful on another ground. I will now turn to allegations relative to indiscriminate bombing of civilian residential areas using cluster bombs and other indiscriminate weapons against the civilian population. Azerbaijan considers that claims related to these facts do not fall under the provisions of the Convention. Armenia believes, on the contrary, that the deaths that occur during these indiscriminate bombings and that are largely documented are perfectly capable of constituting discriminate differential treatment prohibited by the Convention. Why? Because the areas targeted indiscriminately and without any military objective were exclusively populated with ethnic Armenian civilians. Because when Azerbaijan wants to attack in a discriminate manner Armenians' identity, that is to say its cultural heritage, it also does so deliberately and without the slightest hesitation. Evidence of this has been known to the court since the first hearing for the indication of provisional measures. I would like to recall that the cavalier declaration made by President Aliyev to BBC that the double bombing of the Saint Gazan-Shatsos Cathedral of Sushi could have been accidental was proven wrong following ballistic analysis. Because massive attacks on the civilian population had been announced at the highest level as part of a strategy. You can see it as a footnote of our memorial, that it was part of a deliberate strategy aimed at terrorizing ethnic Armenians, because in fact these attacks took place against a backdrop of racist discourse. Now, wouldn't all this constitute violence based on a distinction on a ground prohibited by the Convention? Madam, members of the court, I think that one would have to be blind not to see this and deaf not to hear this. Mr. President, members of the court, Madam Vice President, thank you very much for your attention, and with your permission, I would now like to ask Professor Mercy to make his presentation.
Sir Sean Murphy, the floor.
Bedankt. Je vous remercie, Monsieur le Président. I will address 2 points that cut across all the claims that are the subject of Azerbaijan's second objection. The first point relates to the irrelevance of international humanitarian law, or IHL, to this phase of the proceedings. As Professor Dargent has just explained, there remains considerable confusion with respect to the scope of Azerbaijan's second objection. On the one hand, Mr. Wordsworth assured us that there is no cynical plot afoot. And he says, Azerbaijan is not, of course, saying that anything goes on the battlefield so far as Surd is concerned, or that Surd is somehow displaced by the rules of international humanitarian law. But on the other hand, what does Azerbaijan say in its reformulated submissions, which appear at the bottom of your screen? It says that any acts of murder, torture, and inhumane treatment of members of Armenia's armed forces during the active hostilities phase of armed conflict are incapable of violating the Surd. Forgive us for not being able to square that circle. Given that Mr. Wordsworth defines the active hostilities phase of armed conflict as covering the entire Nagorno-Karabakh war, as well as other open-ended dates, then it certainly looks like Azerbaijan wants the court to find, at least for this case, that anything goes on the battlefield so far as Surd is concerned. Civilians don't fare much better under Azerbaijan's reformulated submissions. They, too, cannot be protected during hostilities by the Surd unless there is specific evidence that indicates misconduct capable of falling within the Surd. One might ponder why a difference is even being drawn between soldiers and civilians. They're both protected persons under IHL and under the Surd, and they were both murdered, tortured, detained, and disappeared in very similar ways. Why is one group completely off the table for the court's jurisdiction, while the other stays on the table so long as the table is properly set? Now, one possible interpretation of Azerbaijan's position is that they have carefully reviewed every single piece of evidence relating to violence against soldiers, and not a single one is capable of demonstrating racial animus, while for civilians, there may be such evidence. I'll leave it to Ms. McDonald to dispel that argument. But another possible interpretation of Azerbaijan's position is that there is something about violent acts against soldiers that, at least in this particular conflict, can only be explained as generalized antipathy between belligerent states, and can only be explained as understandable animosity between two states that have experienced the tragedy of war. On this interpretation, the tragedy of war in this particular conflict has displaced the Surd when it comes to acts of violence against soldiers, and moreover displaced the Surd when it comes to all acts of detention and enforced disappearance. Professor Boisson de Charzon was candid in taking this position when it came to detention, citing specifically to the Third and Fourth Geneva Conventions. Yet arguing that IHL displaces the Surd when it comes to detention is problematic, given that IHL itself requires treating prisoners of war and civilian internees, quote, without any adverse distinction founded on race or any similar criteria, end of quote. Indeed, the prohibition on racial discrimination cuts across both fields such that there is no lex specialis. Similar to the relationship between IHL and the International Covenant on Civil and Political Rights, both spheres of law are complementary, not mutually exclusive. In any event, if we are going to get into questions of whether there is a lex specialis on particular issues such as repatriation that relate to particular facts, such as whether the prosecution of a specific POW is allowed under IHL, then that is clearly an issue for the merits, where both sides can marshal the facts and law as they wish. For present purposes, the only issue is whether the alleged conduct concerning detention is capable of violating the CERD, which surely it is. However one might understand Azerbaijan's position, Mr. President, Armenia stands by its submissions from Tuesday. It is common ground between the parties that in situations of armed conflict, the applicability of IHL does not preclude the application of the CERD, which operates independently. The court has said this, and the CERD committee has said this. And such reasoning is consistent with the court's view that certain acts or omissions may give rise to a dispute that falls within the ambit of more than one treaty. Given the evidence that we have submitted, the claims to which Azerbaijan objects are capable of violating the CERD regardless of any connection to IHL. And as a final point on this issue, if Azerbaijan's position is that claims concerning soldiers and civilians during the so-called active hostilities phase of armed conflict fall entirely or largely outside the CERD, then that position is certainly in tension with the court's prior findings on plausibility in its provisional measure orders in this case. That there were IHL implications to the conduct we allege was well known to the court right from the start of this case. But the court did not see IHL as an obstacle when finding it plausible that CERD rights were at issue concerning soldiers and civilians caught up in hostilities. Mr. President, members of the court, I turn to my second point, which is that Azerbaijan cannot avoid the implications for this jurisdictional phase of the widespread ethnic hatred that it promotes and condones. Azerbaijan's principal gambit on Wednesday seems to have been to pivot away from saying that general Armenophobia is essentially irrelevant for this phase of the proceeding, to saying that it's the only evidence that Armenia has, and moreover, such evidence does not demonstrate ethnic or racial animus. As such, according to Azerbaijan, the second objection prevails. The first problem with that argument is that, as I stated Tuesday, Armenia has presented abundant, direct evidence of the racial motivation behind each and every claim it has asserted. Mr. Wordsworth boldly claimed that my statement was plainly wrong, but then he didn't tell us why it is wrong. Indeed, Azerbaijan has been relatively silent in scrutinizing all the evidence that we have placed before the court, as the speakers that follow will explain. Rather, Azerbaijan seems content to poke at random pieces of evidence while desperately advancing last-minute translations that do not bear up under scrutiny. A further problem is that Azerbaijan's efforts to discount the evidence of general Armenophobia make little sense. Mr. Ahi strained mightily on Wednesday to demonstrate that terms such as wild beasts, predators, jackals, or a savage tribe are terms that can only be understood as referring to a foreign occupying force or to the leadership directing those operations or to the forces of the illegally installed regime. But as the court well knows, that is not how racism works. Racism is an insidious attitude that often manifests through particular types of epithets, phrases, terms, and slogans. Racism is also best understood through the context in which it occurs, whether one labels it background context or relevant factor or something else. And this background context is quite ugly. I will not take the court through all the statements made by President Aliyev that were raised by Mr. Ahi on Wednesday, which are, after all, a mere fraction of our evidence. But in our view, those statements do demonstrate racial animus, or, at a minimum for this jurisdictional phase, are capable of being so read. For example, on Wednesday, Azerbaijan argued that President Aliyev's statement, "Our main enemies are Armenians of the world," is not even capable of showing racial animus. Azerbaijan insists this phrase refers benignly to Azerbaijan's detractors, or those who don't like Azerbaijan. But the phrase Armenians of the world certainly is not referring to a particular country, or to a particular country's leadership, or to its army. The phrase clearly is referring to an entire ethnic group, wherever in the world that group may be found, which includes in Azerbaijan itself. And the phrase is saying that those ethnic Armenians are our main enemies. It was equally interesting seeing counsel for Azerbaijan trying to explain away President Aliyev's references to chasing people like dogs. Here, too, the assertion this week is that dogs can only be understood as referring to the leaders of Armenia or of Nagorno-Karabakh, even though last year Azerbaijan conceded in its written objections that the term has a possible ethnic dimension. In any event, to sustain this week's explanation, Azerbaijan proudly displayed a BBC interview with President Aliyev. But notice the observation made by the reporter before President Aliyev responds. The BBC reporter observes, "You have very recently said, and I am quoting you here, if they do not leave, we will chase them like dogs. Now that's hardly the kind of statement that would make people feel safe." Clearly, the interviewer did not think that dogs was just a clever way of referring to the leaders of Armenia or of Nagorno-Karabakh. Moreover, the reporter then observed, and I quote, there is institutionalized messaging against the Armenians, which takes place here as a part of the state dialogue. People have been primed to have hatred for the other side. Are you actually expecting them to be able to coexist? End of quote. So while Azerbaijan has its own peculiar way of interpreting what President Aliyev means when he says, "We will chase them like dogs," that's not what anyone else is hearing. And it is notable the points we raised on Tuesday that even Mr. Ahi dared not touch. He dared not touch Azerbaijan's parliamentary committee, referring to Armenia and the Armenian diaspora as a cancerous tumor of Europe. He dared not touch Azerbaijan's senior official, comparing Armenians to the Jews of the Holocaust, whom Azerbaijan seeks to eliminate. He dared not touch the grotesque mannequins placed in and then hastily removed from Azerbaijan's military trophy park. He dared not touch Azerbaijan's disinfection stamps, and so on. Azerbaijan's co-agent represented to the court on Wednesday that the patch we noted on Tuesday, which says Armenian don't run, is not worn by Azerbaijan soldiers. That's the first time we've heard such a denial, notwithstanding our having raised this patch as being worn by Azerbaijan soldiers in both our January 2023 memorial and at the October 2023 provisional measures hearing. Azerbaijan's denial happens to be inconsistent with media reports and think tank reports, in addition to social media postings, all of which also say it is a patch worn by an Azerbaijani soldier. In any event, if Azerbaijan wants to contest that proposition at the merits stage, it is free to do so, perhaps by telling us who does wear such a patch that so widely and proudly circulates on social media in Azerbaijan. But there is no need to rely solely on Armenia's interpretation of these facts. Indeed, the court has abundant evidence as to what third parties think about whether Azerbaijan's government generally promotes and condones widespread ethnic hatred against ethnic Armenians. The Council of Europe's Advisory Committee on the Framework Convention for the Protection of National Minorities does not accept Azerbaijan's interpretations of its government statements. Rather, the Advisory Committee has observed, and I quote, a very persistent public narrative surrounding the Nagorno-Karabakh conflict, identifying variably Armenia or Armenians as the enemy and openly promulgating hate messages. End of quote. Moreover, it expressed deep concern at the levels of official involvement in endorsing and disseminating such views, which were directed both against Azerbaijani citizens of ethnic Armenian origin, as well as anybody else who may be seen as affiliated with Armenia. The European Commission on Racism and Intolerance does not accept Azerbaijan's interpretation of its government's statements. ECRI has found that Azerbaijan's leadership, education system, and media are very prolific in their denigration of Armenians, so much so that an entire generation of Azerbaijanis has now grown up listening to this hateful rhetoric. The Third Committee does not accept Azerbaijan's interpretation of its government's statements. Rather, as you will see on the screen and at tab 2 of your judge's folder, at paragraph 27, the committee has expressed concern at the repeated and unpunished use of inflammatory language by politicians speaking about the Nagorno-Karabakh conflict and at its adverse impact on the public's view of ethnic Armenians in Azerbaijan. And I will leave the court with this point. If Azerbaijan is right that everything its government says, from President Aliyev on down, can only be interpreted as having nothing to do with the Kurd, if they're right that all these statements are simply directed at the leaders of Armenia or of Nagorno-Karabakh or at a foreign army, if that was so clear to everyone that these statements were not threats to ethnic Armenians generally, then why, in September of 2023, did more than 100,000 ethnic Armenians, including 30,000 children, within a matter of days flee from their ancestral homeland as the Azerbaijani army approached? If it was so obvious that the years of threats recounted in our evidence, the years of invective against Armenians of the world, only concern threats to the country of Armenia, then why did so many persons, who Azerbaijan claims to be its own citizens, desperately flee for their lives? Could it possibly be that they did not interpret references to chasing dogs as only referencing senior governmental leaders? Could it be that they feared the exterminator soldier that Azerbaijan so proudly placed on its postage stamps? Could it be that they anticipated not just the destruction of their democratic institutions and not just the final cleaning of those ruins by President Aliyev's bonfire, but of their own final cleaning if they did not flee? No. What is abundantly clear is that the words of Azerbaijani officials were rightly understood by the entire population of ethnic Armenians in Nagorno-Karabakh as being aimed not only at government leaders, but at themselves and at their children. It's for this reason that they fled their homes for an uncertain future. This threat and the perception it created, cultivated over decades by the government of Azerbaijan, is highly relevant when establishing that the alleged acts of violence, detention, and enforced disappearance are capable of violating the Kurd. Mr. President, members of the court, that concludes my presentation. I thank you for your attention. If it pleases the court, Ms. McDonald will continue now Armenia's second round.
I thank Professor Murphy for his statement. I now invite Ms. Alison MacDonald to address the court. You have the floor, Madam.
Mr. President, Madam Vice President, members of the court, a few additional remarks on Armenia's claims of discriminatory murder, torture, and inhumane treatment. Starting with the mistreatment of soldiers, as you've seen, Azerbaijan's final submissions ask you to hold that those claims fall entirely outside your jurisdiction. Now, Professor Murphy has demonstrated that your supposed blanket lack of jurisdiction over the mistreatment of soldiers cannot be because of the applicability of international humanitarian law. So what does that leave us with? It seems, by process of elimination, that Azerbaijan claims that none of Armenia's evidence is capable of amounting to racial discrimination in the case of a single soldier. Although it was put a little more coyly, to adopt a term, we heard as much from Mr. Wordsworth on Wednesday. As to the objection, he said, concerning alleged acts against Armenian military personnel in the course of active hostilities, Azerbaijan's position is merely that, so far as concerns the particular allegations made by Armenia in this case, it has not made an adequate showing of mistreatment based on racial discrimination so as to engage jurisdiction under CERD. Trying to grasp Azerbaijan's overall position here, we recall that Mr. Wordsworth made much of the fact that Armenia's claim involves, as he put it, multiple acts of mistreatment. Azerbaijan says that the court must scrutinize every single one of those allegations on the evidence, asks it to conclude that there is no adequate showing of racial discrimination, but, and here is the yawning gulf in the argument, does not itself engage in any evidential analysis of the vast bulk of the claims. You are simply asked to dismiss the entirety of Armenia's claims of the mistreatment of soldiers on the basis of Azerbaijan's bold assertion that the evidence isn't good enough, without, in the vast majority of cases, being told why that might be. Now, such arguments as Azerbaijan does make on the evidence are confined to a few piecemeal and highly questionable linguistic skirmishes. You will recall that the first of these was made orally on Monday, with the debate on whether what was to be, quote, eliminated was the victim's race, as opposed to sort or kind. Azerbaijan followed that up on Wednesday in a letter in which, as you will have seen, it sought to introduce new translations of some of the materials I relied on in my oral submissions. Armenia's response is at tab 3 of your folders. As we noted, this is a remarkable development given that Azerbaijan has had Armenia's translations for months and could have been left in no doubt from either the memorial itself or Armenia's response to the preliminary objections that Armenia relied on them as part of its evidence of racial discrimination. Nevertheless, stung perhaps by these matters being aired in public, it has rushed out some new translations in a last-minute damage limitation exercise. Armenia makes the following points in response to all of this. Firstly, these linguistic debates, if they are to be engaged in, are entirely for the merits. Secondly, it is said repeatedly that Armenia takes words and phrases out of context. But it's hard to see how that is so, given that both Azerbaijan and the court have been given the full set of videos and transcripts. The context, horrible as it is there for all to see. Thirdly, Armenia stands by the accuracy of its existing translations. So, for example, you may recall that I referred to a video in which captured ethnic Armenians, begging not to be harmed, are told that they will be begging a lot and referred to as you, the disgraceful people. Now, Mr. Ochi boldly asserted that, I quote, the word people is not used, and the words that are spoken are insults directed against the Armenian servicemen. Armenia stands by its translation and the use of the word people, and it's no answer, in any event, to say that the words are insults being directed against the Armenian soldiers. Of course they are insults, and of course they are being directed at the captive soldiers. The question is whether, on the evidence, the whole treatment of those people is capable of amounting to racial discrimination. And whatever version of the transcript one reads, that's clearly the position. So this star example of a supposed lack of evidence falls flat. And that takes me on to the fourth point, that it's very difficult to see how any of the new translations really make the situation better. Armenia's letter from Wednesday provides a red line version showing the edits that Azerbaijan has made. But as Armenia points out in its letter, even Azerbaijan's most creative liberties cannot conceal the racism which leaps off the page. And ironically, its, quote, corrections introduce additional racially charged language, such as including the familiar trope, son of a dog. And incidentally, we've still heard nothing from Azerbaijan as to how the frequent use of dog and cognates, including mangy jackal, is consistent with its blanket jurisdictional objection when Azerbaijan itself has acknowledged that the term has a, quote, possible ethnic dimension. Finally, a brief word on civilians. Azerbaijan's final submission asks you to declare that you lack jurisdiction over any civilian mistreatment except with respect to any allegations which Armenia has particularized with reference to specific evidence purportedly indicating misconduct capable of falling within CERD. Now, what does specific evidence mean here? Well, you'll recall the examples I gave on Tuesday of the elderly people, including the 84-year-old man with dementia who were killed and mutilated in their homes. It now seems that these are examples of a wholly undefined category of civilian cases where Azerbaijan goes as far as to claim that you lack jurisdiction. We saw this from Mr. Wordsworth's submissions. He asserted that, as horrific as these instances appear, there is nothing whatsoever to link these acts to racial discrimination. 2 points in response to that. Firstly, the theory here seems to be that appalling violence against elderly civilians is not even capable of being racially discriminatory unless there is a video of racist abuse being shouted at the victims at the relevant time. Now again, it is wholly unclear whether this is a blanket evidential proposition, what claims it might relate to, or why all this isn't a matter for the merits stage. In any event, the proposition with respect sets an absurdly high threshold for identifying acts capable of amounting to racial discrimination. Secondly, none of Azerbaijan's attempts to explain away the soldier cases could conceivably apply here. The heat of battle argument cannot apply to frail elderly people and the many other civilians who were harmed. These people cannot possibly be mistaken for soldiers, let alone for the Nagorno-Karabakh leadership to whom, it is claimed, the hostility of President Aliyev and those below him is confined. Is the court being asked to rule that pure political or nationalist rivalry between Azerbaijan and Armenia explains, to the exclusion of any possible ethnic motivation, murders such as these? In Armenia's submission, none of Azerbaijan's arguments here come close to addressing the abundant evidence before you. Mr. President, members of the court, that concludes my response on why Armenia's claims of violent mistreatment should proceed to the merits. I thank you for your attention and invite you to call upon Mr. Klingler.
I thank Ms. Alison MacDonald for her statement. I now invite Mr. Joseph Klingler to take the floor. You have the floor, sir.
Thank you. Mr. President, Madam Vice President, members of the court, I will briefly address Azerbaijan's objection to Armenia's claims concerning arbitrary detention once again. I begin by noting 6 points that Azerbaijan did not dispute on Wednesday afternoon. First, Azerbaijan did not dispute that the prohibition of arbitrary detention extends through all stages of the judicial process, from the initial detention through to the trial, judgment, and sentencing. Second, Azerbaijan did not dispute that if ethnic Armenians have, on the basis of their ethnicity, been deprived of due process or other fair treatment linked to their detention at any point during their detention, then they have been arbitrarily detained in violation of the CERD. Third, Azerbaijan did not dispute that a discriminatory measure based on a prohibited ground may simultaneously have other objectives and still be capable of constituting a breach of the CERD. Fourth, Azerbaijan did not dispute the existence of numerous first-hand testimonies of ethnic Armenian detainees recounting how they were beaten, coerced into making confessions, and otherwise deprived of their due process rights. Fifth, Azerbaijan did not dispute the existence of first-hand testimonies that link due process violations with what Armenia submits are unequivocal expressions of racial hatred and other racially motivated abuse, the specific terms of which Azerbaijan did not challenge at all. And finally, Azerbaijan did not dispute that many of those it detained were elderly and disabled civilians from Nagorno-Karabakh who did not participate in the hostilities and whom Azerbaijan considers to have been Azerbaijani citizens itself. We respectfully submit that these facts alone are sufficient to dismiss Azerbaijan's objection. By any standard, first-hand evidence indicating that ethnic Armenians were deprived of their due process rights because they are ethnic Armenians is capable of establishing a breach of the CERD. I turn now to certain points that Azerbaijan did address. Much of Azerbaijan's argument on Wednesday appeared to be dedicated to the rather extraordinary proposition that the court must decide on Armenia's claim of arbitrary detention only by reference to the law applicable in times of armed conflict and not by reference to the provisions of the CERD. Professor Murphy has already shown why this is wrong. I would only add that Armenia's position is decidedly not, as Azerbaijan's counsel suggested, that it is enough to transform an allegation into a claim under the CERD simply because a detained person belongs to a particular ethnic group. But it is enough to put forward evidence that is capable of establishing that ethnic Armenians have been deprived of due process on the basis of their ethnicity. And as I have already explained, that is exactly what Armenia has done. In response to the overwhelming evidence of due process violations Armenia has presented, on Wednesday, Azerbaijan could largely only repeat its previous arguments, not just from Monday, but also from more than 2 years ago. In particular, Azerbaijan claimed that its judicial system is not discriminatory against ethnic Armenians because it allegedly refused to uphold charges against Armenian detainees, dropped charges against them, or commuted their sentences. But while Azerbaijan has occasionally released prisoners who were convicted while refusing to commute the sentences of others who were captured in the same place and convicted of the same crime, if anything, that merely underscores that ethnic Armenians have been arbitrarily detained. Azerbaijan also stated that trials against ethnic Armenian detainees took place in open court, in the presence of representatives of the ICRC, the diplomatic corps, the Azerbaijani ombudsman, and the international media. These factual assertions were recycled from Azerbaijan's presentation during the oral proceedings on provisional measures in October 2021. Azerbaijan's October 2021 presentation also referred to the same legal provisions of Azerbaijan's criminal procedure code that it placed in your folders on Monday to show that it respects due process. But Azerbaijan could not convince the court at that stage that it was guaranteeing ethnic Armenians fair trials and due process, which is why the court ordered Azerbaijan to, quote, ensure their security and equality before the law. Azerbaijan's counsel also referred to the trial and conviction of Mr. Vikin Yuljekshian, claiming that Armenia was wrong to assert that he was a civilian. To be clear, at the time of his detention, Mr. Yuljekshian was a civilian. He was captured after the conclusion of the trilateral statement with another civilian while driving in a personal car from Lachin to Shushi to collect his belongings. The fact that he allegedly previously posted undated photos of himself carrying military equipment does not change this. Much less does it change the fact that he was convicted of serving as a mercenary despite being an Armenian national. On Wednesday, we heard nothing about this conviction at all. Mr. Yuljekshian remains behind bars as I speak, convicted of a crime that he confessed to under, quote, apparent duress, and that Azerbaijan has not even attempted to defend before this court. In contrast, we did finally hear from Azerbaijan with respect to Armenia's claim concerning the numerous ethnic Armenians who were not Armenian citizens and were detained at Azerbaijan's ports of entry, merely because they had Armenian surnames. The members of the court will recall that Azerbaijan offered no response to this aspect of Armenia's claim in its written observations or in its oral submissions on Monday. Azerbaijan's primary response, when it finally addressed the issue on Wednesday, was to rely on quotes made by its president in a speech after proceedings in this case were instituted, claiming that Azerbaijan allows ethnic Armenians to enter the country. Of course, whether or not Azerbaijan has occasionally admitted ethnic Armenians to its territory is not the question. The question is whether Armenia has put forward evidence that is capable of establishing that Azerbaijan has arbitrarily detained ethnic Armenians at its ports of entry in violation of the CERD. And that, we respectfully submit, Armenia has plainly done. We refer the court to pages 130 to 136 of Armenia's memorial. Among the evidence cited there, the court will see that relating to an Estonian citizen of Armenian origin who arrived in Baku to participate in a conference alongside other Estonian officials. Although she had officially received an electronic visa, she was held in the Baku airport for 12 hours and then sent back to Estonia by the Azerbaijani authorities after they, quote, noticed their mistake and her, quote, Armenian background. Is any of this ethnic discrimination surprising? No, it is not. In the words of the head of the press service of Azerbaijani Railways, quote, the entry of ethnic Armenians who are nationals of other countries is officially prohibited. Are these just routine identity checks carried out by border guards or customs authorities, as Azerbaijan claims? No, they're not. They are, on their face, blatantly racist detentions carried out on the basis of their victims' ethnicity alone. On Wednesday, Azerbaijan also addressed, for the very first time, the fact that it had not objected to Armenia's separate claim that Azerbaijan has failed to guarantee equal treatment by its justice system. As Armenia explained on Tuesday, if Armenia's claims of unequal treatment in its justice system fall within the CERD, then Armenia's claims of discriminatory detention predicated on unequal treatment in the justice system must fall within the CERD as well. How did Azerbaijan attempt to circle this square? By claiming, for the first time, that it objects to aspects of the court's jurisdiction over Armenia's separate claim concerning Azerbaijan's failure to guarantee equal treatment by its justice system as well. Of course, on Wednesday, Azerbaijan's counsel made no mention of the fact that her colleague had stated just minutes before that Armenia's claims concerning the, quote, withholding of civil and political rights are, quote, recognizable as matters capable of falling under the CERD. Nor did Azerbaijan's counsel mention the fact that Armenia's claims of unequal treatment of ethnic Armenians by Azerbaijan's judicial system include claims concerning the withholding of civil rights. Can it really be said that Armenia's claims of unequal treatment of ethnic Armenians by Azerbaijan's justice system fall within the CERD, except where they concern ethnic Armenians who have been arbitrarily detained? Once again, Azerbaijan has not offered any reason why the court should accept such a counterintuitive point. Azerbaijan's counsel finally claimed on Wednesday that the court cannot rely on so-called reports of general content, which do not constitute first-hand evidence. Well, counsel did not identify which reports she meant, but many of the reports I referred to on Tuesday were based on interviews and first-hand testimonies of returned ethnic Armenian detainees. They are very much reliable for that reason alone. This concludes my presentation. I thank you once again, Mr. President and members of the court, for your kind attention, and I ask that you call Professor Sicilianos to the podium.
I thank Mr. Klinger for his statement. I now invite Professor Dinos Alexander Sicilianos to take the floor. You have the floor.
Mr. President, Madam Vice President, distinguished members of the court, I shall present Armenia's rebuttals on the third and last strand of Azerbaijan's ratione materie objection, namely Azerbaijan's objection to Armenians' claims concerning Azerbaijan's enforced disappearances of ethnic Armenians. I shall also offer some comments on the importance and relevance for the present proceedings of the concluding observations of the Third Committee and of the findings of other UN human rights bodies and special rapporteurs, which has been challenged by Azerbaijan's presentations in the last few days. Azerbaijan cannot dispute that the prohibition of enforced disappearance is encompassed within Article 5's broad and non-exhaustive guarantee of the equal enjoyment of all human rights. The prohibition of enforced disappearance is a rule of customary international law, if not jus cogens, and when it involves racial discrimination, it breaches the CERD. Azerbaijan cannot dispute the concrete evidence that Armenia has presented concerning both servicemen and civilians of ethnic Armenian origin who are believed to have been in Azerbaijan's custody and have either been murdered without the circumstances of their death acknowledged by Azerbaijan or remain missing until today. To be clear, with respect to both categories of enforced disappearances I just mentioned, Armenia refers specifically to those who are known to have been in Azerbaijan's custody, contrary to what Professor Boisson de Chajourne suggested. Moreover, Armenia has also put forward clear evidence that Azerbaijan has repeatedly obstructed searches for and repatriation of the remains of ethnic Armenians in territories under its control. In this regard, Azerbaijan repeatedly relied on its repatriation of more than 1,700 bodies to Armenia following the 44-day war, but does not explain why this is relevant to those ethnic Armenians who were last known to be in Azerbaijan's custody, but whose fates remain unknown today. Finally, Armenia's evidence shows that Azerbaijan has also concealed the fates of ethnic Armenians who were forcibly disappeared following the submission of Armenians' memorial. Counsel for Azerbaijan did not contest such evidence. Mr. President, what is striking is Azerbaijan's complete failure to challenge the palpable ethnic element of discrimination in all the above cases, many of which are documented by video footage. That element is even more visible in numerous cases of completely inoffensive civilians, including elderly people up to 90 years old and persons living with disabilities, who were the last to flee due to their age and yet were subjected to enforced disappearance by Azerbaijan. Again, Council for Azerbaijan did not give any explanation how the subjection of these individuals to enforced disappearances could be based on any grounds other than ethnic hatred. Yet Azerbaijan somehow claims that there is no specific evidence of differential treatment based on ethnic origin concerning Azerbaijan's practice of enforced disappearance of ethnic Armenians. To be clear, the question whether there is a practice or practices of enforced disappearances based on existing evidence is an issue to be examined at the merits. This is therefore a transparent attempt to deflect from the weaknesses of Azerbaijan's objection at this stage and the central issue to the court's consideration, namely the ethnic dimension that Armenia has amply shown. I come now to my second point, namely the relevance and importance of Third Committee concluding observations and findings of other prominent UN experts and special rapporteurs. Armenia has extensively invoked the findings of the Third Committee in its concluding observations of 2022, in which the committee examined almost all claims of Armenia in its memorial concerning a period including the 44 Days War. Yesterday, we heard from Professor Boisson de Sajourne that such concluding observations should be disregarded by the court. Comme il a été mentionné lundi dernier, les observations du dit comité ne sont pas d'assistance à la Cour afin d'établir sa compétence en vertu de la sièdre. This is in stark contrast with the opening statement of Mr. Mamadov, the agent of Azerbaijan in this case, in Geneva in 2022, during those same committee proceedings which resulted in the adoption of the aforementioned concluding observations. I quote Mr. Mamadov, "We highly appreciate the dialogue with the committee, which significantly contributes to our efforts for overcoming existing challenges and making further progress. The Republic of Azerbaijan considers the interactive dialogue with the committee as a significant mechanism for monitoring and reviewing actions taken by the government to fulfill its obligations under the Convention." End of quotation. As it is well known, the concluding observations of UN human rights treaty bodies in general, and of the Third Committee in particular, are the corollary of the whole process of examination of states' reports, which includes a 6 hours constructive dialogue with the state delegation and considers a broad range of contributions by a variety of independent stakeholders, including other international bodies and institutions, as well as NGOs contributing first-hand information and testimonies. It is true that the concluding observations are not judicial decisions. They are adopted in a specific framework, and as Mr. Mamadov observed, they claim at helping states to fulfill their commitments under the Convention. However, when a committee expresses deep concern about a series of acts or omissions of the state under examination, as the Third Committee did in relation to Azerbaijan in 2022, this is a very alarming sign addressed to the state in question based on multiple converging sources. The court places high importance on UN treaty bodies' findings of facts and law in its judgments and advisory opinions. As the court explained in relation to the Diallo case, although it is in no way obliged in the exercise of its judicial functions to model its own interpretation of the Covenant on Civil and Political Rights on that of the Human Rights Committee, It believes that it should ascribe great weight to the interpretation adopted by this independent body that was established specifically to supervise the application of that treaty. Similar considerations apply to the other treaty bodies, including the Third Committee. Let me recall the main findings of the Third Committee concluding observations in relation to the preliminary objections of Azerbaijan, which you can see on your screen. The committee is deeply concerned about allegations of severe and grave human rights violations committed during the 2020 hostilities and beyond by Azerbaijani military forces against prisoners of war and other protected persons of Armenian ethnic or national origin, including extrajudicial killings, torture and other ill treatment and arbitrary detention. The invitation to the court to simply disregard the findings of the specialized treaty body on issues of racial discrimination concerning a significant part of the period and context related to Armenia's application is most surprising. Azerbaijan is inviting the court to consider that the findings of the Third Committee do not even pass the threshold of the preliminary stage of proceedings. This would constitute a serious blow to the authority and credibility of the Third Committee and to the UN treaty body system more generally. All the more so that the above approach by Azerbaijan could be applied mutatis mutandis to the statement at tab 5 of your judges folder from Tuesday, emanating from two special rapporteurs, the chair rapporteur and 4 other members of the working group on enforced or involuntary disappearances, all democratically elected by the Human Rights Council, which you can see on your screens. May I recall that special rapporteurs and working groups are part of what is known as special procedures of the Human Rights Council, that is the largest body of independent experts in the UN human rights system, constituting independent fact-finding and monitoring mechanisms that address either specific country situations or thematic issues in all parts of the world. The above-mentioned statement covers not only enforced disappearances, but also extrajudicial killings, torture, and other ill treatment against ethnic Armenians during and in the aftermath of the 44 days war, as you can see on your screens. Joint statements of this kind are relatively rare in UN practice, and they concern only egregious violations of human rights. Azerbaijan's logic of summarily disregarding such statement would inflict yet another blow to the UN human rights protection system. By way of conclusion, let me reiterate that the enforced disappearances of ethnic Armenians fall within the scope of application of the Third. This claim is corroborated by the findings of the Third Committee, as is the case with all of Armenians' claims which have been the subject of Azerbaijan's preliminary objections. The same observation goes mutatis mutandis for the findings of the UN Special Rapporteurs and the members of the UN Working Group on Enforced or Involuntary Disappearances. Mr. President, members of the Court, this concludes my presentation. I thank the Court for its kind attention, and I kindly ask you, Mr. President, to call upon the agent of Armenia, His Excellency Mr. Kyriakosyan, to present Armenia's final submissions. Thank you very much.
I thank Professor Sicilianos for his statement. I now call upon the agent of Armenia, His Excellency Mr. Kyriakosyan. You have the floor, Excellency.
Mr. President, Madam Vice President, members of the Court, it is an honor to appear before you once again this week. I will be brief. This week, Azerbaijan failed to respect the clearly circumscribed limits of the preliminary objections phase. It disregarded the legal standards clearly established by the court's jurisprudence, and it distorted Armenia's factual evidence. But Azerbaijan's tactic has failed. Its stance is not conducive to good administration of justice. As Armenia's Learned Council demonstrated this week, Armenia genuinely attempted to negotiate its claims under the CERD, but to no avail. Armenia thus fully complied with the negotiation precondition of Article 22 of the CERD. Moreover, all of the Armenia's claims fall squarely within the material scope of the CERD. Azerbaijan's racist violence, arbitrary detention, unenforced disappearances perpetrated against ethnic Armenians are plainly capable of falling within the CERD. As you saw this week, these horrific practices are anathema to promise undertaken by all state parties to the CERD to, and I quote, adopt all necessary measures for speedily eliminating racial discrimination in all its manifestations and forms, and to prevent and combat racist doctrines and practices in order to promote understanding between races and to build an international community free from all forms of racial segregation and racial discrimination. End of quote. The court has before it all the necessary elements to easily dispense with Azerbaijan's objections. Armenia looks forward to continuing its pursuit of accountability in the proceedings on the merits, and reconfirms its dedication to resolve this dispute peacefully and in a manner that honors both the letter and spirit of international law. In accordance with Article 60, Paragraph 2 of the Rules of the Court, I will now read out the Republic of Armenia's final submissions. The Republic of Armenia respectfully requests that the Court, A, reject the first preliminary objection raised by Azerbaijan, and B, reject the second preliminary objection raised by Azerbaijan, or, in the alternative, decide that Azerbaijan's second preliminary objection does not possess an exclusively preliminary character. Before concluding, I wish to express my gratitude to the Registry and its staff for their kind assistance in these proceedings, to the interpreters for their hard work, and finally, Mr. President, members of the Court, thank you for your attention and serious consideration of the parties' submissions this week hearings. Thank you.
I thank the agent of Armenia for his statement. The Court takes note of the final submissions which you have just read on behalf of your government. Ainsi s'achève la présente série d'audiences. Je tiens à remercier les agents, conseils, avocats des deux parties pour leurs interventions. Conformément à la pratique habituelle,
I shall request both agents to remain at the Court's disposal to provide any additional information the Court may require. With this proviso, I declare closed the oral proceedings in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan, on the preliminary objections raised by the respondent. The Court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the Court will deliver its judgment. Since the Court has no other business before it today, the sitting is declared closed.